Paul. I just got to the study room and it's 2:44. I got here about 4 minutes ago. Yeah. And just kind of loading my phone. There seemed to be this big question about, well, we just can't remove the protection order because we have continuing jurisdiction. But you don't. In fact, you never had jurisdiction. The problem with this whole concept of the state has exclusive continuing jurisdiction for the protection for the minors. Yeah. um, you don't have continuing exclusive jurisdiction when you did not give actual notice. Now, this is not in bold print. This is in what's known as italics, ITALICS. Yes. Now, I think a lot of times when they make these court forms, they put this actual notice. Yeah. See the font right here? This is straight up and down, and this is sideways. Yes. Represented a credible threat. Now that's in italics. And was an intimate partner. That's in italics. Now, a lot of times these court employees that work for the state judicial system, they do it that way so that judges will pay very special attention to the italics. Yes, yes, yes. Now, this is my copy, and you can see here a little better. Yeah. Respondent had actual notice, in italics, represented a credible threat, yes, and was an intimate partner. This is in italics, this is in italics, and this is too, yes. Now, I know that when the individuals that are employed in the state of Washington, when they go through these court forms, see, there is no italics here. The petitioner shall have exclusive custody and control of the following pets. But this is prohibited. See how that's bold right there? That's bold right there. This is the findings. That's in bold print. Must issue the above orders and in order to surrender weapons because, that's in bold print. This is may issue the above orders and in order to surrender weapons because the court finds by preponderance of evidence the respondent. Now, obviously, there wasn't a preponderance of evidence. Presents a serious and imminent threat to public health or safety. Or the health or safety of any individual by possessing a firearm, other dangerous weapon, or has used, displayed, or threatened to use firearm or other dangerous weapons in a felony. Yes. Or previously committed an offense making him or her ineligible to possess a firearm. Now, you mark this one right. Findings must order to surrender in italics. See, I've never owned a firearm. I've never owned a gun. I never have. And I've never violated this protection order, but you don't have continuing it. See, the problem is the court found on page 1 that respondent had actual notice. Exactly how did you think that I was a credible threat when you issued this on July 31st of 2015? Yes. And I had been found not guilty in May 29th of 2012. Yeah. What possessed you to want to issue it? Oh. And considering the dissolution of marriage, was an intimate partner like 4 years before that, probably 5 years. It was in June of 2011. And you issued this in July of 2015. I hadn't actually been an intimate partner for over 4 years. So I just wanted to know in the state exactly how long does it have to be between when you have sex with somebody um, what was your reasoning for issuing this order to surrender weapons? Because as I see it here, yes. You didn't actually fill out the petitioner's name or respondent? Yes. But they put this in bold print, actual notice and an opportunity to be heard. The restrained person had actual notice and an opportunity to be heard. There are some prosecuting attorneys probably saying, well, he got notice after we issued it, but did I have an opportunity to be heard? Or you're still excusing yourselves. Well, he had a remedy. He could motion the court if he had a problem. Is that right, Mr. Cowgill? That's not what the state court form says. It says that I had actual notice and an opportunity to be heard before you issued the order to surrender weapons and before you issued the protection order. It doesn't say we issued it and there was no actual notice to be heard and there was no opportunity to be heard. Now, who's the fucking dick that absolutely refuses to remove their fraud from this state in the United States because that's the fraudulent ideas of a prosecuting attorney? Now, I have showed you that the respondent did not receive actual notice of the hearing. Yes, the respondent did not have reasonable notice and an opportunity to be heard. This is page 1 of 6. Yes. It actually mentions page 1. The court found on page 1. Page 1 right there? Yes. Now, I don't know how many times. I mean, I could probably do a search of the form if I wanted to download it from the website. But there's an additional fraud, yes. And not only not having an actual notice, but you lied about the first restraint provision is ordered above, and the court found on page 1. Poach. Now I'm going to sue you for violating number 1, the fraud of saying that the court found on page 1. Yes. The court didn't find on page 1 because on page 1 it says he didn't. I'm going to sue you for that fraudulent statement. On page 1 of 6, yes. Notice of this hearing was served on the respondent by personal service, service by mail, or service by publication. Coach, you see how it says court found on page 1? Yes. The court finds based upon the court record. Now let's look at the court record together, shan't we? Let's see. On June 1st of 2015, you reissued the protection order. Yes. Without any attempt of service between June 1st and June 12th. And then you reissued it without it being within the 90 days before the expiration of the previous protection order. Yes. And then you reissue the temporary protection order because of the court record. This is what's known as a court. This is summary court case summary. Yes. This is what's known as the case docket. Okay, confidential, not for release. Yes. I have a copy of it and that I did get from the public court record. Okay. Now, court finds based upon the court record. The court record. Okay. Now, you reissue this. Yes. Protection order. And it says not served and not served. Oh. Now, not only did you fraudulently issue this because you said the court found on page 1, yes, but page 1 says that the court found that the respondent did not get actual notice. In fact, the public court record says that there was no service. Now, you're being fucking assholes. I want you to remove your fraud from this state, every state in the United States. Do you fucking understand?